Number 81, matter of Rochester Police Locust Club versus City of Rochester.
And may it please the court, Andy Celli for the City of Rochester. Council, I'd like to reserve 3 minutes for rebuttal.
Yes.
Your Honors, in 1907, the state legislature expressed the policy of the state of New York that disciplinary authority over police officers in Rochester needs to remain in the hands of local officials.
Counsel, I'm sorry, is it your position that you can never permanently give that up, or that what Rochester did here didn't have that effect?
Well, it's both, but it seems to me that the state legislature has to repeal what the state legislature gave. That the setting of policy in this extremely sensitive area of policing is done at the state level, and obviously there were different ways.
The argument being they did give that up. I mean, they passed the Taylor law, and now you bargain that. So this is a grandfather situation. And I guess I'm struggling a little bit with the argument that you can give that up. And again, I'm not saying it was done here, but if you did, and then you can say, no, we want a grandfather again.
Well, I think part of the problem is the characterization of this as a grandfather. What this court has held on numerous occasions is that in passing the Taylor law, it wasn't as if the state legislature said, we have a general rule, and anybody who that doesn't apply to for now is grandfathered, but later on if they change their behavior, they lose the grandfather, they lose the exemption. That's not what the Taylor law said, according to this court. What the Taylor law said is there are two kinds of municipalities in the state of New York. Those that are required to collectively bargain over police discipline, and those that are prohibited from collectively bargaining on the same topic. That both of those policies are extremely important to the state, and that the second one, the idea that there are communities and municipalities that are prohibited from bargaining, that is equal in value to the state as a policy, as the general policy that applies where the state has said nothing. So
what about the policy interests at play with the municipal home rule law? Could you respond to this New York City amicus brief on that point, which I think suggests a different position?
Sure. I mean, look, I think we have to wrestle with the municipal home rule law. Obviously, I think that's essentially what the Rochester Police Locust Club is relying on. And they're saying that Rochester was allowed to overrule the state policy set forth in 1907, and that's what they intended to do. And it's true that the municipal home rule law does permit the overruling of some state laws in very specific ways. But
Well, that's actually the question. You said two different things. One was overrule the state policy, and the second was overrule the state law, and that may make a difference.
Well, the state law that the Rochester Police Locust Club is saying was overruled, there are two. One is the Taylor law, and
Right.
I think that's extremely important.
My question is whether you think the municipal home rule law gave municipalities the ability to overrule state laws or to overrule state policy.
I think they are, under very limited circumstances, permitted to overrule either, but those circumstances don't apply here. And the general rule of the municipal home rule law is that they are not permitted to do anything at the local level that's inconsistent with the general law or with state policy. I think
That sounds to me like an articulation of Dillon's rule, which, is long gone at this point. And that's the problem with the current state of the municipal home rule law, which is municipalities do have the discretion to adjust their policy priorities in a way that they didn't before. The only issue is, I know you don't like to call it grandfathering, but the only issue is sometimes these policy choices are meaningful and difficult to undo.
The municipal home rule law, as we see it, and this also goes to Judge Halligan's question, is really about moving power within the municipal structure. That's what it's designed to permit. And that is, in fact, what Rochester has been doing every 10 years or so since the 1920s. One year it's the Public Safety Commissioner. They decide to transfer the authority to the chief. Later on, they split the authority. And now in 2019, after 2 years of debate and a public referendum with 75% of Rochester's voters supporting it, they said we're going to have a new public agency, a new city agency called the Police Accountability Board. All of that is consistent with...
But how is that a local, how is that a governmental entity?
Well, it is by definition under the charter. It's a city agency. Its employees are city employees. It's appointed by public officials, subject to nomination by a variety of different entities. But in terms of the municipal home rule
But in
law,
terms of the chain of command in the police department, aren't they independent?
yes.
Are they
but that-
outside that chain of command?
And
And isn't what the law and the, I want to ask you about that law and policy binary in a moment, but isn't that what those laws are referring to, that chain of command?
Well, this is a point that was
Opposed to
made
an
in,
external independent entity?
right, this was a point that was made in the city of New York's amicus brief to the court, and it's an interesting point, but it is not really founded in this court's jurisprudence. What the municipal home rule law is about is moving around power within the structure, number one. And as I said, Rochester's been doing that for decades. Number two, we know that the state of New York has blessed the moving of authority over discipline for policing to civilians. It's happened, it happens regularly in Orangetown, in Wallkill. There's
But
nothing
what you're
unusual.
missing is, though, and what you skipped over was what happened in 1985.
So I think obviously we have to wrestle with that. That's the core of the case. The 1985 amendment was, we contend, a housekeeping measure designed to align the charter with what was already happening at the time, and to basically, and this is according to the language, the legislative history that appears, to make things more efficient and more productive. It was not, and there's no words that reflect this anywhere, that this was an attempt to surrender authority, which
But to that point, right, what it says is, it specifically references the charges and trials, which I think was the original provision which authorized local control over police discipline. And it says for the reason that it's covered by the civil service law. So while it doesn't say expressly, and we intend to surrender our pre-existing control, can you tell us why it doesn't do that just on the face of the text?
Well, I think that, I mean, if one looks at the face of the text, one can say that the city council at the time believed that they didn't have the power one way or the other, that it's covered by the civil service law, which, by the way, I think it's very important to pause on this. Covered by the civil service law is an incredibly vague statement. The Taylor Law is but one article of the civil service law. There are several others, including Section 75 and 76, that don't apply at all to Rochester by definition.
In 1985, was this also at a time when the city had negotiated a contract with the police union, which included a provision regarding police discipline?
Exactly right, Judge Egan, and in fact had been doing it for a decade. So the idea that this...
What's the effect of that, if any?
Well, I think it contextualizes what happened in 1985. What the Locust Club would have you believe is that in 1985, the city council decided, now is the time we're going to surrender our power, and that's what the 1985 amendment means. That's ahistorical. That's
Surrender the power to impose police discipline.
Correct,
Right.
correct.
And then the city thereafter continues to periodically negotiate new contracts,
Exactly, but
setting forth.
But more importantly, in my view, Your Honor, is that the city was doing it for a decade as of that point.
So you're
And as of 85, excuse me, I'm sorry.
No, go ahead, finish
I
your
was going to say, as of 85, this court's critical ruling in the New York City PBA case was still 21 years in the future. So they want you to believe that there was an intent to surrender with a 21-year foreshadowing when in fact the city had already been collectively bargaining over discipline for at least a decade.
So, counsel, what I get from that statement is that in 1985, the city council made de jure what was already happening for years de facto. But I don't understand, the question we're facing here, the balancing of rights under the Taylor Law versus municipal home rule, doesn't speak to what was actually going on. It just talks about legislative enactments and localities passing laws. I don't understand why, even if it had been going on earlier, once that law gets passed, that's an affirmative statement by the municipality that we have opted to go with the the civil service law and the Taylor law provisions therein.
Well, I think that last piece respectfully is not supported by the record, by what we actually know Rochester was doing at the time, because they don't mention the Taylor law, and they don't mention collective bargaining, and they don't mention any of those things.
They mentioned the civil service law,
The
right?
civil service law, and I want to say one word about that and then switch to Section 22 of the Municipal Home Rule Law. The reference to the civil service law, we don't really know what Rochester intended at the time, and I think my friend on the other side agrees with that. It's an unknown, and that's devastating to their position. Why? Because Section 22 of the Municipal Home Rule Law says if you want to overrule a state law and you're acting under the Municipal Home Rule Law, you have to identify it with specificity, and this court's jurisprudence in the Turnpike Woods case says you have to show it with definiteness and explicitness. And that's not here, because the reference to the civil service law is too broad. Now, if we look historically at what happened in '85, you had in the collective bargaining agreement at the time, Sections 75 and 76 of the civil service law, which are the procedural sections, were actually incorporated into the CBA at that time. So one way to read the text, again, to Judge Halligan's point, one way to read the text is they were saying, look, we don't have to have trials and charges as a separate provision of the charter because it's already in the collective bargaining agreement, which incorporates civil service law section 75 and 76, not civil service law 200, which is the Taylor law. That's an invention, in my view, an invention that's been imposed, I see my time is up, that's been imposed in response to this lawsuit. I see my time is up, and thank you.
Thank you.
Good afternoon. May it please the court, Dan DeBolt for the respondents. This court has repeatedly held in multiple cases that where Section 75 and 76 of the civil service law apply, police discipline in that jurisdiction is a mandatory subject under the Taylor law. That's been the case in Rochester since 1985. What Rochester City Council in 1985 had to be explicit about.
Why isn't he right about this last point he was making, which I understood him to say, he can correct me, of course, when he gets back up for rebuttal, that all that happened was that Rochester adopted the procedural aspects of these two sections, not that it was giving up its local control of discipline. Why isn't he right about that?
I think he's not right about that because what they expressly did, and in terms of the municipal home rule law, what they had to be explicit with is we hereby repeal Section 8A7 of the city charter. That was the state law that they were repealing. That's what they had to be explicit about. The consequences that flow from that of, okay, you no longer fall within the grandfathering provision of Section 76, which is what this court used to say that's the expression of public policy that favors local control over police discipline. You don't get there because you're not getting out of Section 75 in the first place anymore.
So what prevents them from readopting that charter provision?
Because the municipal home, the 2019 legislation was not authorized under the municipal home rule law because it did conflict with a general law. Once the earlier provisions of the city charter were gone and didn't exist anymore, now when they go to take action in 2019, state law, general law, the Taylor law, requires bargaining over police discipline in Rochester.
With respect to the 1985 law, in terms of understanding what Rochester meant by it, are you relying only on the words of the provision, or is there any other evidence you think is relevant as to understanding the intent?
No, I think it's the words of the provision is really all we have. We don't, anything related to what city council's understanding of the law at the time, their understanding of the purpose for repealing those earlier city charter provisions, that's just speculation at this point. There's nothing in the record that would allow a determination one way or the other about what they meant, and certainly not enough to overcome the presumption that a legislator is aware of the status of the law at the time it takes actions. And while City Council repeatedly says that the PBA case didn't come until 2006, that was not breaking new law. That was affirming 2 decades of decisions from the appellate division which had held the same thing, the first one coming from the Second Department in 1983. So 2 years before City Council took action here, there was appellate division law that said if you have a pre-existing statute in place governing discipline in your locality, you don't have to bargain under the Taylor law. And with that in place, they said, we're repealing our pre-existing legislation that governed police discipline. At that point, there is nothing other than Section 75 and 6 of the Civil Service Law and the Taylor law.
Section 22 of the municipal home rule law didn't create any sort of obligation or need to articulate that they were, bringing on or invoking the obligations under the Taylor law. That wasn't part of the equation.
No, that was simply a consequence that flowed from their repeal of the existing city charter provisions by virtue of the line of cases from this court.
So it's possible that they may legitimately have not been aware of the consequence of the decision about revoking the local authority rule, right?
That's certainly a possibility.
That just doesn't matter?
It just doesn't matter. It certainly cannot be the rule that 20, 30, 40 years down the road, a legislature realizes there was some unintended consequences of something we did decades ago, so we now get to treat that as a nullity, as if it never happened.
But isn't that different from, I'm certain I want to make this decision, but I don't have the foresight to see fully what will be the consequences of that versus I'm making this decision because I believe it's the only option I have. And then down the road, you discover that you do have options. Aren't those two different things, or am I misunderstanding your argument?
No, I don't think that matters for the purposes that we're looking at here. I don't think either one of those provides a ground to go back and nullify, decade-old legislation, whether it was because you thought there was no choice or you thought you had a choice and you made one choice over the other. I think the decision is made, and you have to live with the consequences, and in many cases...
But isn't the point of the state law and the state policy that it has to be a conscious decision? It can't be a mistaken decision that the localities make? It has to be the affirmative choice?
No, it has to be an affirmative choice to repeal the charter provisions that they did. I don't think it necessarily, if they...
They don't have to list all the consequences.
Right, if they didn't
Not
realize...
about consequences, but about, we, in this moment, think this is the right thing to do, fully aware of all of the options. But if one is not fully aware of the options, are you really making a choice which is in line with what the state policy is? That was my question.
No, and I don't think there's a distinction between the two for these purposes.
And the fact remains that prior to whatever the city did in 1985, and after whatever it did in 1985, it continued to negotiate with the police union collective bargaining agreements containing provisions relating to police discipline.
Correct. And they continued throughout that period to utilize Section 75 as explicitly the basis for the disciplinary action, and conducted the hearings pursuant to the procedures negotiated in the collective bargaining agreement, which just slightly modified Section 75 by providing for a neutral hearing officer.
Could they have done, so let's say that you would agree that some action in the past did not cede this control. Let's say you agreed with that. Could they then decide, we're going to try out negotiations. We're going to see how that works. And then decide, we're not so happy with that. We're not going to agree to that in the future. Could they have done that?
No, I don't think I think they could have done that up until 1985. They could have engaged in the bargaining even though it wasn't technically permitted under the statutory framework. That's the Schenectady case.
Okay.
They were for years doing it even though they didn't realize they didn't have to be. But once that pre-existing legislation is gone, I mean, that is the crux of what the court used in the PBA Wallkill Schenectady to find a public policy that trumped the Taylor Law's policy in favor of bargaining. So once that is gone, that's it, nothing else matters.
No, I think I'm sorry, I was trying to ask something different. Let's say they never made that choice. They were merely trying out, I think in some in some way, it's what counsel was suggesting with the briefing, experimenting with different ways of properly effectuating discipline, right? And so, for a period of time, they decided, let's try and bargain. Let's see if that is something that we find is effective, efficient, works for us, ensures public safety, and so forth. And then they've changed their minds.
I think it depends on how they went about going to do that. If they just left the pre-1985 legislation fully in effect,
Yes?
and in practice went on to collectively
Yes.
bargain, they may have reserved their right to
Okay.
pull back on that. If they accomplished it through legislative changes, and I think it's an important distinction because the public policy here was that under the Taylor law, collective bargaining is done by the chief executive officer. In the case of Rochester, it's the mayor. The line of cases was really saying, where you have this particular statutory framework in place, we are not going to let the executive of a municipality usurp the legislative designation for police discipline. It's different here where you had the legislative body changing that legislative structure. Now there is no usurping of authority by the executive. The legislature made the choice to give that authority to the executive. If there's nothing further, I'll rest. Thank you.
Thank you.
I'd like to pick up on Judge Rivera's questions and my adversary's response. The idea that it just doesn't matter whether the City Council of Rochester knew that they were surrendering rights. This is the position of the Rochester Police Locust Club, leads them to the place where Rochester cannot change its mind. It's the most anti-democratic position that one can take in this case. It's a remarkable and breathtaking, in my view, position. And it violates every principle and every idea that we have coming down from Holmes, who said that government has to respond to the felt necessities of the times. We have exactly that here.
Isn't that really a little bit different here because of the overlay of the Taylor law? In other words, it's not simply a notion that you abdicate power into a vacuum, but that there is a separate state law which imposes a policy preference.
But there are two policy preferences. That's, I think, so critical to this case.
So to go back to the home rule issue for a minute, I think Judge Canataro asked you why what I'll call the one-way ratchet theory is not essentially Dillon's rule. Can you, I'm not sure I followed that. Could you respond to that?
I mean, look, Dillon's rule was the idea that every time a municipality wanted to do anything, essentially, that tinkered with the charter, they had to run to the legislature and get approval of the state legislature. It's very inefficient. It's very 19th century. And so in the early 20s, we had a constitutional amendment and legislation that followed that said, we're going to allow local legislatures and local leaders to do certain things, not anything, but certain things. And the things that they permit, if you look carefully at the municipal home rule law, are really about tinkering about who within the structure that's been created by state law, who within that structure is going to exercise certain kinds of power.
But what do you do about the Taylor law then coming in and saying something arguably different with respect to this specific question?
I don't think it says anything different. I think the Taylor law, and this is this court's own words in the three cases, and even going back to the 1970s, to the Cohoes School District case and the Great Neck Union Free School District case, what it's really saying is there are two kinds of municipalities in the state. Those that are required to collectively bargain and those that are forbidden from collectively bargain. It just doesn't contemplate.
Counsel, can I get back to your policy argument that you made when you first stood up for rebuttal? Because I was thinking the same thing, that a policy choice made by the state legislature in 1967 is, when I was just learning how to walk, basically, is now binding a municipality in 2023 when they may have a very different set of priorities. Clearly, in 67, it was important for public employees to have collective bargaining rights. In 2023, how police are disciplined may be the hotter issue. So it was kind of stunning to me that they're stuck, or that there would be an argument that they're stuck with that choice as a result of, amending their charter. But we have recognized that policy, and the state has said that policy is paramount in a way that they did not do so anywhere else, or was certainly not with anything having to do with police discipline. So how do we just escape the legislature's own priority of policy statement?
The critical difference here is that in the case of the Taylor Law, the legislature can and most recently did change it and has the power to do that. That's Chapter 674 of last year's
So should we be looking to them
session.
to
No,
reorder the priorities?
My point is that we are not stuck with what 1967 said if the legislature wants to change it, the state legislature. What the union is saying is that the city council itself cannot change its own rule, cannot do anything. There's a big difference, and I think the critical case, Your Honor, is the Morin versus Foster case from 1978 in this
Let me ask you,
court.
this, and I'm sorry, your light is on, if I could. So let's say 2 years from now, new government, they pass a local law that says we're going to collectively bargain with the police, we're going to follow the civil service, we're giving up our charter rights. 2 years later, that government gets out. Can they pull that law back then?
Our view is that based on from Coho School District up until the three cases.
No, but my question, can you pull that law back and then say, we negotiated with you, police union, but now we're not anymore because we've got a change in government and we're, you can't buy in the future here.
Right.
Could you do it, yes or no?
I think yes. I think yes. But to get there, you have to undermine 3 decades of precedent in this court, which says that municipalities cannot surrender this particular power. That's the problem. But if you get there, if this court reaches that point and says,
Under our law as currently stands, if the fact pattern is as I gave it to you, could Rochester go back to the union and say, we bargained with you for these 2 years, well, this government was in place, but they can't bind us now, we've issued a new law, now we don't have to bargain with you anymore, it's over, we're doing a new process. Under the law as it currently stands, do you believe you can do that?
no, not as it currently stands, only if this court changes its jurisprudence.
But I want to understand that answer. The reason that you're saying no is because you think it's a prohibited subject of bargaining about which they can't give that up at all. They can't collectively bargain.
Exactly.
It's not that they can't restore it, it's that they can't give it up in the first place.
Exactly, yes. You said it better than me, Your Honor, exactly. And that's 30 years of jurisprudence. That's going back to 1976.
So even under the home rule provisions, they could never change the law?
The state legislature can change the law, but the locality can only change who within the structure exercises the power that they have. That's the limitation of the municipal home rule law. I see that my time is up, and thank you, Your Honors.